Any application referring to several goods or services, hereafter referred to as the initial application, may be divided by the applicant into two or more applications, hereafter referred to as the divisional applications, by distributing among the latter the goods or services referred to in the initial application. The divisional applications shall preserve the filing date of the initial application or the benefit of the right of priority. Section 129. What is the concept of divisional application? The concept of the divisional applications comes into play when two or more inventions are claimed in a single application, but are of such a nature that a single patent may not be issued for them. The applicant is thus required to divide, that is, to limit B claims to whichever invention he may elect, whereas those inventions not elected may be made the subject of separate applications which are called divisional applications. SmithKline-Beckman Corp. of the Honorable C.A. Supra. Certificate of Registration, prima facie, evidence of validity. A certificate of registration of a mark shall be prima facie evidence of the validity of the registration, the registrant's ownership of the mark, and of the registrant's exclusive right to use the same in connection with the goods or services and those that are related thereto specified in the certificate. Section 138. Issuance and publication of certificate. The certificate of registration shall be issued when the period for filing the opposition has expired, or when the Director of Legal Affairs shall have denied the opposition, and upon payment of the required fee. Section 136. The registered mark shall be published in the form and within the period fixed by the regulations. Marks registered at the office may be inspected free of charge, and any person may obtain copies thereof at his own expense. This provision shall also be applicable to transactions recorded in respect of any registered mark. Section 138. Cancellation or amendment of certificate. Upon application of the registrant, the office may permit any registration to be surrendered for cancellation, and upon cancellation, the appropriate entry shall be made in the records of the office. Upon application of the registrant and payment of the prescribed fee, the office for good cause may permit any registration to be amended or to be disclaimed in part, provided that the amendment or disclaimer does not alter materially the character of the mark. Appropriate entry shall be made in the records of the office upon the certificate of registration, or, if said certificate is lost or destroyed, upon a certified copy thereof. Section 140. Correction in case of a mistake of IPO. Whenever a material mistake in a registration incurred through the fault of the office is clearly disclosed by the records of the office, a certificate stating the fact and nature of such mistake shall be issued without charge, recorded, and a printed copy thereof shall be attached to each printed copy of the registration. Such corrected registration shall thereafter have the same effect as the original certificate, or in the discretion of the Director of the Administrative, Financial, and Human Resource Development Service Bureau, a new certificate of registration may be issued without charge. All certificates of correction heretofore issued in accordance with the regulations and the registration to which they are attached shall have the same force and effect as if such certificates and their issuance had been authorized by this Act. Section 142. Whenever a mistake is made in a registration, and such mistake occurred in good faith through the fault of the applicant, the office may issue a certificate upon the payment of the prescribed fee, provided that the correction does not involve any change in the registration that requires republication of the mark. Section 143. Use of a mark in a different form. The use of the mark in a form different from the form in which it is registered, which does not alter its distinctive character, shall not be ground for cancellation or removal of the mark, and shall not diminish the protection granted to the mark. Use of a mark for goods belonging to the class registered. The use of a mark in connection with one or more of the goods or services belonging to the class in respect of which the mark is registered shall prevent its cancellation or removal in respect of all other goods or services of the same class. Use of a mark by related company. The use of a mark by a company related with the registrant or applicant shall inure to the latter's benefit, and such use shall not affect the validity of such mark or of its registration, provided that such mark is not used in such manner as to deceive the public. If use of a mark by a person is controlled by the registrant or applicant with respect to the nature and quality of the goods or services, such use shall inure to the benefit of the registrant or applicant. Duration of Certificate of Registration. Duration. A certificate of registration shall remain in force for 10 years, provided that the registrant shall file a declaration of actual use and evidence to that effect, or shall show valid reasons based on the existence of obstacles to such use, as prescribed by the regulations, within 1 year from the 5th anniversary of the date of the registration of the mark. Otherwise, the mark shall be removed from the register by the office. Section 12. RA number 166A. Non-use of mark. Non-use of a mark may be excused if caused by circumstances arising independently of the will of the trademark owner. Lack of funds shall not excuse non-use of a mark. The special circumstances to excuse non-use in affidavits of non-use shall not be accepted unless they are clearly beyond the control of the registrant, such as the prohibition of sale imposed by government regulation. Renewal. A certificate of registration may be renewed for periods of 10 years at its expiration upon payment of the prescribed fee and upon filing of a request. The request shall contain the following indications: A. An indication that renewal is sought. B. The name and address of the registrant or his successor in interest, hereafter referred to as the right holder. C. The registration number of the registration concerned. D. The filing date of the application which resulted in the registration concerned to be renewed. E. Where the right holder has a representative, the name and address of that representative. F. The names of the recorded goods or services for which the renewal is requested, or the names of the recorded goods or services for which the renewal is not requested, grouped according to the classes of the NICE classification to which that group of goods or services belongs, and presented in the order of the classes of the said classification, and G. A signature by the right holder or his representative. Such request shall be in Filipino or English and may be made at any time within 6 months before the expiration of the period for which the registration was issued or renewed, or it may be made within 6 months after such expiration on payment of the additional fee herein prescribed. If the office refuses to renew the registration, it shall notify the registrant of his refusal and the reasons therefor. An applicant for renewal not domiciled in the Philippines shall be subject to and comply with the requirements of this Act. Renewal of marks registered. Prior to Republic Act Number 8,293 marks registered under Republic Act Number 166 shall remain in force and effect, but shall be deemed to have been granted under Republic Act Number 8,293. Such marks shall be renewed within the time and manner provided for renewal of registration by the regulations issued under the current law. Marks whose registration have a remaining duration as of January 1st, 1998 of more than 6½ years shall be required to submit the declaration and evidence of actual use within 1 year following the 10th and 15th anniversaries of the registration or renewal registration under Republic Act Number 166, provided that marks whose registrations have a remaining duration of 6½ years or less may no longer be subject to the requirement of declaration and evidence of use, but shall be renewed within the time and in the manner provided for renewal of registration by these regulations, and upon renewal shall be reclassified in accordance with the NICE classification. The renewal shall be for a duration of 10 years. Trade names and marks registered in the Supplemental Register under Republic Act Number 166, whose registration, including any renewal thereof, was subsisting as of January 1st, 1998, shall remain in force, but shall no longer be subject to renew one, with the application for the renewal of a registration made under Republic Act Number 166, the certificate of registration to be renewed must be surrendered to the office if the official copy of such certificate of registration is not in the files of the office. After he has surrendered the certificate of registration granted under Republic Act Number 166, the applicant for renewal may, if he so desires, Obtain a certified copy thereof upon payment of the usual fees.